Our next panel will discuss harassment in the workplace and the role of the General Counsel not only in preventing harassment, but also creating a positive work environment, especially through presenting the corporate legal department as a role model. I'd like to welcome our panel, starting with our moderator, Paul Gibson, Commercial Director of Labor, Employment, and HR at Bloomberg Law; Theodore Borromeo, Assistant General Counsel of Employment and Benefits Law at McKesson Corporation; Lisa Hamasaki, Partner at Ogletree, Deakins, Nash, Smoke, and Stewart; Kimberly King-Webb, Deputy General Counsel at Christus Health; and Roberta Steele, Regional Attorney in the San Francisco District Office of the Equal Employment Opportunity Commission. Thank you. It's a bright light.
Thank you, Susie, and good afternoon, everybody. As Susie said, we're going to talk about harassment, managing the risk of harassment in today's enhanced awareness and climate of harassment.
Yes.
In October of 2017, the New York Times and the New Yorker magazine published articles outlining a series of allegations against the movie producer Harvey Weinstein, alleging a history of misconduct in the workplace. We're all familiar with that. Shortly after those articles came out, the actress Alyssa Milano started a campaign on Twitter with the hashtag #MeToo, which was designed to increase awareness and encourage other people to come forward if they have been mistreated in the workplace with harassment. In January, another group was created called Time's Up. That group was created largely by some Hollywood celebrities with the goal of increasing awareness of misdeeds in the workplace, fostering corporate policies that encourage people to come forward with complaints about misdeeds in the workplace, and setting up a legal defense fund to assist people to hold management accountable where there has been misconduct in the workplace. According to the New York crisis consulting firm Temin and Company, about 417 high-level executives have been held accountable since those allegations came out in October, and that does not include situations where it's been dealt with privately. This is based on news articles and lawsuits. This has obviously had an impact on the workplace. According to Bloomberg Law reporting, the Equal Employment Opportunity Commission has seen an increase in the traffic to their website, although they haven't seen formal charges yet. But we have talked to management lawyers who said that they are seeing increased internal complaints and increased demand letters from plaintiffs' lawyers. And whether or not those become actual charges with the EEOC will really depend on how effective we are as corporate counsel in creating policies and procedures to deal with internal complaints. So that's what we're going to focus on today with our panel. We've got a good panel of corporate counsel, management representation from outside counsel, as well as the EEOC. And we're going to talk about how we manage risk for harassment complaints in this environment of increased awareness of harassment issues. So I'd like to start off with a general question for each of the panel members, and I'd like to start with Roberta from the EEOC and just ask Roberta, given the climate that we're in right now, what's the focus of the EEOC?
Well, as you all know, sexual harassment in the workplace has dominated news headlines in recent months. But this is not news to the EEOC. It's not new to us about the prevalence of sexual harassment in the workplace. The number of sexual harassment charges that are filed annually across the country with the EEOC has hovered around 6,700 since 2010. And this covers all job settings, job titles, and industries from the fields to the boardrooms. And in addition to sexual harassment, about a third of the 80 to 90,000 charges that we get across the country annually allege harassment, not just based on sex, but based on other protected categories under our statutes as well. So in January 2015, the EEOC convened a task force to study workplace harassment to address this, what we viewed to be a seemingly intractable problem. It was a 16-member task force made up of people from academia, advocacy groups from the employer and employee contingencies, as well as lawyers who represent both employers and employees, and organized labor groups. They worked on this project for 18 months, and their work concluded in June of 2015 with a report of findings and recommendations concerning harassment in the workplace. Well, the EEOC has continued to build on this groundwork from 2 years ago. And we got from Congress for this fiscal year a $15 million budget increase that was actually unrequested, unsolicited, for the purpose of addressing sexual harassment. So what have we been doing recently? We reconvened the task force for a public hearing earlier this month to hear testimony from members of the public, and as well as advocates and lawyers about what they are currently seeing in the realm of sexual harassment in the workplace. We work, and our work comes under 3 prongs in this area. We are the agency with the expertise on the laws and interpreting the laws, and so we have been doing, for example, work with Congress as well as the judiciary to develop robust sexual harassment protocols and policies and procedures for them. We also, the second prong is education, such as providing training to employers, and then the third is enforcing the law through investigation of charges and litigation when necessary. Since October of 2017, the agency has filed 15 enforcement lawsuits alleging sexual harassment, including 8 that were filed in the 2 days after the public hearing held earlier in June. And these lawsuits encompassed diverse industries across the country, such as commercial cleanup, trucking, staffing agencies, restaurants, manufacturing facilities, and shipbuilding facilities. And many of these lawsuits were filed on behalf of vulnerable workers. Since October of 2017, the agency has recovered almost $4 million, $3.9 million, for sexual harassment victims in 16 different settlements. The average settlement was a little under $250,000, and the high was $850,000. So that's just a recap of what we have been doing since October.
Thank you, Roberta. Lisa, as outside counsel, what types of issues are your clients bringing to you in the new climate?
Well, I think as you'll hear a lot about, we haven't seen and I haven't heard a lot about an uptick in the number of complaints. There has been, and I've heard sort of anecdotally from colleagues in the industry and others that sometimes when the complaints come in these days, they have a lot of legal language in them. You know, they're referring specifically to harassment, not just to describing conduct and things of that nature. So really the types of issues that I've seen come up the most are employers trying to get ahead of these types of complaints, making sure that they're checking their policies to ensure that they provide adequate means to escalate or to complain, that they're distributed to their employees. Another big upturn is a lot of employers are asking about investigations, making sure that their internal folks are well trained on how to do investigations, making sure that the folks that they're giving their investigations to have the right outlook as they go into investigations, because there is a real effort to jump on a complaint and do your prompt and thorough investigation as quickly as possible. I will tell you also that just being part of the employment defense community in the area, I know a lot of attorney investigators who do external investigations, and I've heard from quite a few that they're as busy as they've ever been. So those are the main areas I've seen.
Thank you. Ted, what is your organization, what's been the impact on your organization?
Well, you know, I will say that having worked now at 4 companies with tens of thousands of employees, essentially 4 towns or 4 cities, things sometimes happen that you prefer not happen. But I have to say that we have not seen that kind of uptick either. It's not been an issue for us. I think more the discussion we're having is, what if something happens? How do we address that? Especially if you're dealing with old claims or incidents that happened years ago. Those present very difficult, challenging issues from an evidence standpoint, from a witness standpoint. And really, you think about, whether or not the person who's making the complaint or the alleged perpetrator is still at the workplace, that will impact what you do. You think about potential discipline in those circumstances. How do you apply the standards today that apply, or do you apply the standards that might have been in effect back then? So those are the kinds of conversations that are happening in the in-house community with other companies, as well. What do you do? What if? So I think it's trying to be proactive and anticipate. But in terms of actual upticks, we're not seeing it.
Okay. And Kimberly, how about in your organization? What's been the effect on your organization with the increased awareness?
Well, there's definitely increased awareness. I can't say that we've seen a significant uptick in the amount of complaints, but I will say that I have seen, as part of the legal department, an uptick in complaints that reach the legal department and either go through or sometimes bypass the regular HR protocols that we have in place. I think that increased awareness, coupled with trainings, in-person trainings and other trainings that we do to make people aware of all of the different avenues that they have in order to bring a complaint forth internally. So not just our anonymous hotline, or not just HR or your manager, but really any leader in the organization, including legal. So I definitely have seen more to come past my desk. Or people who feel like maybe HR is not as empowered or as effective and kind of want to skip ahead in line to have their concerns addressed. I think there's a healthy awareness now. I think there's some hypo-awareness with people tending to couple a lot of different things in harassment. And, for example, I was late to work 5 times and my manager wrote me up for it. I feel like I'm in a hostile work environment, as opposed to real serious concerns. So we have we have both. But to deal with all that, I think that, companies like my company and many, many others are just being very proactive, looking at our policies, reviewing our trainings and how we're doing that, making tweaks as necessary, and investigations, making sure that we have the right people investigating and that they're very capable of investigating these issues as they pop up internally and trying to resolve them as much as we can.
So you raise a lot of good points there, so let's follow up on a couple of those. Lisa, with regard to complaints or making sure that we get complaints so we can resolve those internally, a lot of the high-profile cases we've seen had a long history of serial misconduct, and yet people didn't come forward. So what can we do to make sure that we become aware of complaints? Are there changes in policies or changes in procedure that you would advise to be made?
Well, I don't know that it requires necessarily a change in policy, but you do need to have a policy that provides avenues for people who feel that they've been the victim of harassment to come forward. And the more avenues, the better. So you can skip your supervisor, or you can skip to HR, or if you don't trust HR, maybe there's a hotline, or the more avenues, the more comfortable people are coming forward. And then the other piece of it also is just to make sure that it's not just a piece of paper, a policy, but that there's buy-in all the way through the organization, and that the message is conveyed to employees that they will not be retaliated against, that they are encouraged to come forward, and that their complaints will be investigated and will be taken seriously.
If I may add to that, I think, reinforce what Lisa says. I think it's tone from the top, the work environment and the culture. So commitment by your CEO to diversity and inclusion, support for affinity groups, opportunities or different avenues for people to raise concerns, you know, HR, legal, compliance hotline, lawyers, you know, give employees many different ways that they can get their concerns reported. I think all that contributes to helping in this area.
Once we have complaints and we got a good environment where we're sure that people are comfortable coming forward, what action should we take in terms of auditing complaints or monitoring complaints? Ted, I think that in some prior discussions you mentioned that this is something your team does.
Well, I think a lot of companies do this. It's just monitoring, working with HR, and if you have an employee relations group, with that employee relations group to see if there are any patterns, anything unusual that's occurring at a particular site, a particular department, and doing a deeper dive on why that might be. It may not be a legal issue, but it's something, if you have the information, you look at that, and I think that's what a lot of companies do.
So what kind of
I think that's the best practice.
What kind of patterns are you looking for, though?
Well, just complaints, you know, and are they similar about a manager, for example, or management? You take a look at that. And, working with HR on the ground, kind of have that conversation, what's going on here, and is there an intervention that's appropriate, and what should that look like?
And we do the same thing. I mean, we take a look at any EEOC charges that come in. If we see that there's more, not just in sex, but with age, disability, whatever, we're looking at that to see if there's some focused, targeted training that needs to be done in an area. We're looking at hotline complaints and looking at that in the same way. And most recently, this past week or two, I've been looking at our results from our employee satisfaction, employee engagement survey, because they will tell you a lot about the culture. I think all these companies have policies about sexual harassment. If you don't have a policy, then you're under a rock. But it really is the accountability and the culture. And so that employee engagement survey tells me a lot about just answering the question, do I feel like I'm being respected by my manager, by my coworkers? And I can't, I mean, there's certainly a correlation between if I feel like I'm being respected and I feel like others are respectful of different cultures and different people in the workplace, and do I feel like this is an environment that I can bring complaints and concerns. So, I mean, I think all of that information is very helpful, and it all goes together very well. I mean, one of the other issues that we have is union avoidance. And so, again, if people are being respected, people are not filing lawsuits against you and not seeking union activity necessarily. I think it really relates.
I just wanted to add that with respect to when complaints are coming in and vetting them, making sure that they're handled, one point that is really something to be avoided is well, I'll start with, if a complaint comes into HR, if it comes into legal, it's going to be reviewed, it's going to be handled. But there are other avenues to make complaints. If employees go to some low-level line manager who they just feel comfortable talking to, the employer is still going to be on the hook for having knowledge of that complaint, but those managers don't always know what to do. So one thing that's really important, especially in a climate like this, is to make sure that all of your managers understand their obligations when they get a complaint and understand how broadly they need to interpret the term complaint. An employee doesn't need to come and say, I'm complaining, I feel like I'm subject to a hostile environment. I'm complaining, so-and-so is harassing me. The facts of the discussion could be enough to give rise to the need to investigate and escalate the situation.
I think that that's a critical area because, you know, one of the things that I hear is, can I have an off-the-record discussion? Like, I'm the employment lawyer. What are you talking about? Like, so, but managers get that, and so they feel like, oh, well, I'm going to keep their confidence and you know, they've had this off the record discussion, or "Hey, I'm just venting," and really they're putting the employer or the company on notice. And I just have to give a shout out because the EOC has done, I'll give them credit when it's due.
Oh, thank you. I can't wait to hear this.
But if you don't know, if your company doesn't know where to start and needs to start from scratch, or just needs a refresh, like the Select Task Force's report is gold on what needs to be in your training, what types of things that you need to be training your employees on, what needs to be in your policy. So Google it, it's great, and it can really kind of guide you on some of those issues with dealing with those first line managers.
What's interesting is I've been listening to people talk. I mean, I'm hearing you say things that were recommendations that came out of the task force report. Perhaps that's just coincidental, but we do have a wealth of compliance information on our website at eeoc.gov. And one of the things, actually, we have our checklists for employers that have been developed for employers about leadership and accountability issues in the workplace and how important that is to preventing discrimination and harassment. There's also a checklist for developing an anti-harassment policy, another one for developing a harassment reporting system and investigations, and another one for developing compliance training. So if you're a smaller employer that perhaps does not have the resources of a McKesson or another big corporation, or does not have an in-house lawyer, these compliance resources are great. There's even a chart of risk factors for harassment and responsive strategies. So you sort of look at your workforce, and different factors can cause, such as if it's a diffuse workforce, if it's a male-dominated workforce, if it's a workforce with a lot of facilities, a lot of vulnerable workers, that could be an indication that you could potentially have a harassment problem that you would want to monitor things maybe a little bit more closely. So.
May I just throw in my outside counsel warning? Well, the materials are terrific on the EEOC website. If you're in California, and you're dealing with coming up with your policy and what the training requirements are, just remember that the requirements in this state and in other states can be specific to the state. And there's also the California Department of Fair Employment and Housing has materials on their website about some of the laws that are specifically applicable to California employers.
So speaking of policy, what is your advice when you have a company that's dealing in multiple states that may have different requirements depending on the state or even the locality that they're in terms of drafting policies?
Well, maybe Ted has a good answer, but because you do have these, I mean, it really depends on the policies that we're talking about. But with respect to policies like an anti-harassment policy and training, you can really go one of two ways. You can either have the most protective policy, protective to employees, and issue it out across all offices, or you can have specific policies. And there are pros and cons to each. And so I'm kind of curious how you do with it, Ted.
Well, I was going to say that the folks here who have operations in multiple states are going to have this question come up like real time, because right now there are a number of states that are either just passed legislation or have proposed legislation that will impact what you do with respect to sex harassment claims. Training, confidentiality provisions, arbitration provisions, and there are different states that are starting to legislate in this: New York, Maryland, Washington. And so you're going to have to decide, is it the lowest or highest common denominator that you use for those kinds of things? Or do you try to tailor it to a particular state? And obviously cost is going to be an issue when you think about doing it state by state. And I think the other factor here is the corporate culture and values. I mean, do you want to have one standard that you want to apply to all locations and all employees, or again, do you want to do a state-by-state approach? So I think it's an issue that we're looking at. You know, we haven't come to a decision because these proposals, these and laws are literally just being passed. So, but it's something that everybody's going to have to consider.
We mentioned investigations. So how do you go about deciding the proper person to lead an investigation? What are the decision factors on whether you do it internally or externally? And what are the considerations when you have a high-profile executive, for example, that's the subject of an allegation? And anybody in the panel wants to take that?
Well, I'm happy to start. I would say the most important thing that I look for when I'm advising on an investigation, a complaint comes in, and who should investigate, is to make sure that the person who is investigating is well suited to be an investigator. Whether it's internal or external, you need to make sure those people are trained, that they're going into the investigation with an open mind, that they have the right level of sympathy, but also of fact-finding, and frankly, that they're able to articulate and they'll be able to take the process all the way through. And from my perspective as an outside lawyer, I also look at how that person will describe the investigation, should it ever come to that, whether they're going to be able to adequately describe the decisions they made, who they decided to interview, why they made certain findings. So should it come to a claim or litigation, I want to make sure that person can tell the story accurately and well about what they did do. I think there are some differences when it comes to very high-level investigations, for example, C-suite investigations. It is, for those types of investigations, it's absolutely critical that there be buy-in from the very highest level and that there be support of the investigator. And so in those types of situations, you don't want some low-level HR generalist investigating because there may be a perception of potential risk that the employee might be afraid to come forward and make findings against a COO or a CEO. So those are the situations where either you really need somebody who's high up in the chain of command that can do the investigation and be unbiased and without any fear for their own jobs, or go externally.
Yeah, in that regard, if I'm thinking about the Uber case that many people have read about. There was the board that conducted the investigation being assisted by outside counsel. I think when you do have somebody at that level, it behooves you to retain outside resources, whether it's you're an outside law firm or an investigator. I recently read an article that mediators are getting into this business of doing fact findings because they have the skills to do it. So I think we're going to see different kinds of practitioners get involved. But I think when you do retain an outside counsel, make sure it's not your regular outside counsel that you might need to defend you, because then they would have a conflict. Those are the kinds of things that you'd think about.
Roberta, when the EEOC is reviewing a charge intake, how important is a good investigation in analyzing how they're going to respond to that charge?
Well, first and foremost, we're trying to discern if there was a violation of the law, if in fact there is evidence upon which we can conclude at the administrative stage that it's more likely than not that the harassment actually occurred. We will review the investigation and gather evidence about the investigation that the company conducted, and at times that will go into our finding as well as to whether we think the investigation was adequate.
Okay. Shift to training. We talked about the importance of training different levels of employees in the organization, and also the importance of culture. Kimberly, I think you had an interesting story about how you've maybe shifted some of your training philosophy recently. If you'd like to share that with the...
Sure. So this year is the first year that we have implemented in-person live training per one of the EOC's recommendations, for all of our managers. So anyone who has a direct report is required. It's a mandatory training. That's a lot. It takes a lot of time and resources to get that done, especially for a healthcare system that has 24-hour operations and people who work various shifts. But we're doing it, and we're doing it because our CEO made it a priority. And so that kind of goes back to tone at the top, and making it a priority for the culture. So we're doing that. We happen to be in a state primarily, or in states, Texas, Louisiana, New Mexico, where the state does not require a mandatory training like California, but we're doing this as a best practice, and we are also doing a webinar training for all employees so that they can get the same information about our policies and how to bring complaints forth. So those are a couple of things that we're doing, and it's been really, really well received. One thing about the training is that we really have taken away the focus on what's legal and really focused on what's acceptable. We've kind of gotten away from the law and really talked about our policy and our culture and our core values, one of which is dignity for everyone. And so when you think about dignity and respect of people, how does that translate to dealing with harassment?
Coming out of the task force report and recommendations, that was one of the key findings in the EEOC's report, that the training should be a tool of prevention, and that we need to move away from training being overly focused on legal liability and move toward more preventive models such as civility training and bystander intervention training. Commissioner Feldblum is fond of saying, when she talks about this, she says, we want to nip it in the bud, meaning that if there are problematic behaviors that are going on within the workforce, that before it gets to the point where it's an EEOC charge or it's a lawsuit, that there are steps taken to address that behavior.
I also just point out, while we're on the topic of training, that there is a piece of legislation currently pending in California that would expand the harassment training in the state for California employees. Currently, employers with 50 or more employees are required to do 2 hours of interactive harassment training for supervisors. And if this bill passes, and I understand it's in committee currently, it would decrease the number of employees to 5 employees, and it would expand the group of people to be trained to include both supervisors and non-supervisors. So it's something to keep an eye out for.
One of the things the EEOC task force report found too is that it's important that the training be tailored to the specific workplace. So if, for instance, if you're managing a construction site, you don't want to have training that's focused on a workplace that's maybe an office setting where the issues are very different than the issues that would come up on the construction site.
Okay. Pretty much every case I read about harassment will include a retaliation claim in it. Mm-hmm. What are some of the best practices, and I'll ask you, Roberta, in terms of making sure that you don't open yourself up to a retaliation claim in addition to the underlying harassment claim?
I have a lot of data points. About 40% of the EEOC charges that are filed annually contain a retaliation component to them. So this is also, just based on looking at that, a pretty widespread problem, or at least a widespread perception by employees that they are being retaliated against when they come forward and complain. And retaliation has, there are also studies that have found that workplace harassment often goes underreported. Studies show that more than 85% of victims never file a charge, 70% never complain internally, and 75% who do complain about harassment are then subjected to retaliation. And retaliation either socially or professionally. And by socially, that can mean being ostracized in the workplace or being shunned by coworkers, as well as having a manager take an adverse action. I think that, what the task force found was that in order to have employees feel safe about coming forward to bring complaints to the attention of the employer internally, they must feel that there is a trusted and accessible complaint reporting process and investigation procedures. Another component goes back to the training for managers and supervisors to make sure that they understand what retaliation means and what they should do or they should not do when they find out that one of their employees has brought forth a complaint that perhaps against them for their behavior and their conduct.
If I may add, sure. I think on the topic of retaliation, it doesn't require proof of the underlying claim, discrimination. It's another claim, and it's much easier to make. And what I tell people is that juries get retaliation. They think of their 5-year-old, and when they see a 5-year-old playing with a playmate, and the playmate hits the 5-year-old, what does that 5-year-old do? Hit back. And juries get that. So they get retaliation, so it's particularly, a danger. So reminding witnesses that the company doesn't tolerate retaliation, to report it, reminding the alleged perpetrator that he or she should not engage in behavior that could be perceived as retaliation are all very important parts of the investigation process.
And one of the other things that I try to do is, these things don't happen in a vacuum. So, very seldom you get someone, sometimes you get someone who complains and they have a spotless record and they've never had any performance issues, but many times it may be someone who has had some performance issues or conduct issues, and they also complain about harassment or discrimination of some sort. So it's a lot of gray, and it's often kind of like the race to the courthouse. It's the race to HR about who can get to HR first sometimes. And so one of the things that I really try to train our managers on is that they are documenting performance issues and all those things in real time, and not waiting until a problem pops up and then it's like, oh no, this person has been, a slacker for years and I want to get rid of them. Well, wait, no, they just complained last week. So what's the deal? So if they're really doing their job and managing folks and documenting issues in real time, then it really helps to say, no, you're not being terminated because you filed a complaint. We have a litany or documentation of the real legitimate business reason, which I think the EOC really wants to see. So that's one of the key things. And then also following the buddy system, because managers don't really know what retaliation is, and sometimes it's like, oh, I'm just going to avoid the person because I don't want to I don't want to do anything, which in itself could be considered retaliation. So trying to help them understand that, and also, if resources allow, making them or strongly encouraging them or requiring them to work with HR so that they're not making these decisions in a vacuum.
Making sure, just to sort of add on to what you're saying, is making sure your managers feel supported, because it's also an uncomfortable position for them to be in, to have had a complaint made against them and then still be expected to manage performance, even if it had started well before. The next time you have a meeting and you have to go through a performance issue, even if it had been long-standing, they're going to be very uncomfortable with the process. So making sure they understand that they're being supported, that they need to treat the person just as they would have had there not been a complaint, follow up with the management issues, notwithstanding the complaint.
One result of the heightened awareness around harassment issues may be that some managers may feel reluctant to put themselves, quote, at risk by having meetings alone with a woman or mentoring junior women or something like that. So are there unintended consequences that we have to watch out for in the workplace as a result of this heightened awareness and perception around harassment?
Absolutely. I can give you a very good example. In trying to cure one problem, you don't want to create another kind of discrimination or engage in another kind of discrimination as a result. Our office, our St. Louis office, a number of years ago had a sexual harassment case against a trucking company that female trainee truckers were being sexually harassed and sexually assaulted when they would go out on drives with trainers, male trainers. This was our allegation. And that case ultimately settled. We settled the sexual harassment claims, and the company decided apparently that the way to avoid having any more sexual harassment claims was just not to hire any more women in truck driving positions. So there was a second lawsuit for hiring discrimination that was settled within the last year or two. So.
Any other thoughts on
Unintended.
working with managers and making sure we don't fall victim to unintended
I think an unintended consequence, more prosaic as an example, but is our company policies that say we have zero tolerance for sex harassment or some behavior, and everyone thinking, or the people involved thinking, well, that means you fire for the first offense. And that's not necessarily the case. I think that's an unintended consequence, that people think that, when actually what the law requires is that you take corrective action to stop the behavior. So it could be something less than termination.
Right.
Absolutely.
Okay. Let's talk a little bit about settlements and confidentiality clauses. The Tax Cuts and Jobs Act in 2017 included a provision that said that settlements for sexual harassment would no longer be tax deductible if you had a confidentiality clause. We also know that given the heightened awareness, it may have an effect on juries and how they perceive the issues. So, Ted, when you're thinking about settling right now and have a potential settlement issue, how do you balance the confidentiality clause, the tax deductible issues, the risk assessment of the current jury clause?
Speaking like a lawyer, it depends, right? So, in talking to my peers, I think in this area, if you're settling a substantive or substantial harassment claim, you're going to want confidentiality, whether or not you get the deduction. But you could have a situation, in contrast, where it's not a big deal. I mean, it's a small nominal amount, and the allegations were not significant, where you don't really care if it's not confidential. And so you go ahead and put that confidentiality agreement or take out the confidentiality agreement. So I think, it depends on the situation, but I have to say that probably in most cases, most in-house counsel would prefer the confidentiality agreement.
Lisa.
Well, I was just going to say one interesting aspect of this new law is that the issue with the tax deductibility of settlements and attorney's fees is not limited to the employer. So, for example, if you're resolving a case and you want to have a confidentiality provision in it, and the case involves sexual harassment, part of the settlement sum might often be payment for the complainant's or the plaintiff's attorney's fees. And in the past, that was always a deduction. But the way the law is written, it's not necessarily a deduction anymore, provided there's a non-disclosure confidentiality provision. So there might also be the consequence of increasing the amount of potential settlements, because a plaintiff is now going to be, or a claimant is now going to be on the hook for paying taxes on the attorney's fees portion of any settlement sum.
There's some practice pointers here too. So in your boilerplate release, you got to make where you have the employee waive all claims and you identify sex harassment, you could have a problem, right? So you've got to look at that. Some defendants are now doing separate releases, one different one for sex harassment, and allocating some of the consideration to that claim and the rest of the consideration to another claim. So there are things that you can do from a practice standpoint. We just have to be mindful of this law and what it could mean.
And there are also a number of state laws that are sort of following suit that are in progress. So.
See, Susie's here. We may have some audience questions.
I am here, and we do.
Okay.
So we have a few questions from the audience. The first one, I'm just going to read it because it's a little bit long. The New York Times recently published a long piece on pregnancy discrimination and the subtle ways it can affect a woman's trajectory and career. Do your companies see any issues regarding this, and have you tried to take a proactive approach to this form of subtle or not so blatant discrimination?
I haven't seen a lot of issues in this area. I think that the few issues that have popped up are probably like most companies where they kind of fall into maybe a along the same lines as a disability discrimination case. If someone needs additional time off outside of FMLA leave and how we deal with that. I know being in a hospital setting and having very physical job requirements for some of our staff in lifting patients and things like that, we look at it in the same way. Can we provide a reasonable accommodation for someone who has a lifting restriction or something like that? So, but it hasn't been a big issue for us. We really just try to accommodate it as much as we can. And where we can't, we make sure that we are able to show why it's an undue hardship to do so and kind of follow that same line of thinking as with disability discrimination claims.
Okay. The next question, what can companies do to ensure that HR isn't seen as protecting only the leadership level, such that more junior employees feel HR is a resource for them and a secure place to report potential violations?
Well, one of the things that I would say is that you need to make sure that your HR are communicating well with everyone. So it may be that every time a complaint comes in, no matter who it's from, it's investigated. But one of the things that I do see in my practice is that the person who made the complaint doesn't necessarily find out that the investigation has been done or that it's ongoing and when it's completed and that the company took it seriously. And making sure that your HR are not only trained to dealing with the actual issue that comes in, but communicating with the people who are coming forward can help to make them far more accessible or seem more accessible to everyone.
I think a lot of it is messaging by HR. I think, this is a difficult topic. I don't think it's, even with the hashtag #MeToo movement, I don't think it's any easier for women to come forward and make complaints. I think HR being empathetic and expressing understanding of the employee's concern goes a long way towards that and making that connection with the employee. So I think that would be important.
I think also transparency to the extent possible. Again, as Ted said, this is it can be a difficult situation, but to the communicating what your complaint policies and procedures are and what the investigation policies and procedures are, and conducting investigations promptly and communicating to the extent that you can to the employee about the status and the outcome, I think will go a long way to making having employees trust in the system. And the other thing with that is having a message from the very top of the company, encouraging people to come forward with their complaints, going to HR and assuring people that they will be treated respectfully and that their complaints will be investigated.
I think the reality too is that you could get sued by either the complaining individual or the alleged perpetrators. So your process has to be fair to both. And with respect to the perpetrator, you've got to assure that person that he or she will have an opportunity to respond to all the allegations, so that they're not left out there. So it's this balance you have, but trying to be transparent, trying to communicate, because as I say, there's a good chance if things go wrong, you could get sued by both, and that's not a good place to be.
Great, and we have one more question. You touched briefly on settlement agreements already, but this question slightly varied. What are your thoughts on NDA provisions in settlement agreements, and how do you evaluate the risks of foregoing such provisions? And is the answer different when thinking about those on the whole versus sexual harassment claims?
Well, I think having confidentiality or non-disclosure provisions in settlement agreements that don't involve sexual harassment are generally advisable. It depends, again, on the complaint, though, and on what's at issue. There are times where you don't need them, obviously. But with respect to the sexual harassment claim, I think we already dealt with that, and Ted gave his example earlier of if it's a low-value case, then perhaps you want to, or a case you don't mind getting out or being public, then you can forego that NDA in exchange for being able to deduct the settlement.
If you're litigating with the EEOC, we will not agree to confidentiality provisions or non-disclosure agreements. We litigate, although we're seeking to recover remedies for the charging party and any claimants, we are litigating in the public interest. It is our lawsuit, and any settlement has to be pursuant to a consent decree that is filed with the court and then approved by the court. So if you find yourself in that situation, it's different than, the negotiation will be different than if you are negotiating with a private party.
Thank you. Those are all of our audience questions. So thank you very much for a great discussion, and please join me in thanking our panelists. That brings us to our afternoon networking break. So please feel free to refill your coffee, stand and stretch, and meet us back here at 3 to start our next panel on fostering internal relationships. Thank you.